Codification of Civil Procedure and Introduction to CPC. Civil Procedure Code 1908. Introduction. The Civil Procedure Code was passed in 1908 and came into force from 1st January 1909. The Civil Procedure Code neither creates nor takes away any right. It is intended to regulate the procedures followed by the Civil Code. And laws can be divided into two groups. First one is substantive law, second one is procedure law. It is also known as adjective law. What is a substantive law? Substantive law is the set of laws that govern how members of a society are to behave. Substantive law defines rights and responsibilities in civil law and crimes and punishments in criminal law. This is called substantive law. So what are the examples of the substantive law? Indian Penal Code is best example for substantive law, and second one is Indian Contract Act and Transfer of Property Act. These three are best example for substantive law. Adjective or procedure law. So what is the procedure law? So procedure law, adjective law in some jurisdiction referred to as a remedial law. So it is also known as remedial law. Or rules of courts comprises the rules by which a court hear and determine what happens in civil, lawsuit, criminal or administrative proceedings. So what are the examples of the procedural law? So civil procedure code. So this is called CPC, Code of Criminal Procedure, CRPC, Indian Evidence Acts. These three are best examples of the procedure law. So come to the history of the code. So before 1859, there was no uniform civil procedure applicable for the entire country. So Charles Wood was responsible, then president of the board for the affairs of India, instructed the Second Law Commission to prepare a simple code for applicable in all Indian courts. Although it was not applicable in a presidency Supreme Courts and presidency small cause courts. This code had several issues and was amended and reacted in 1877. Another amendment was made in 1892. There existed a conflict of judicial opinion and interpretation of certain procedure of the code. Between 1909 to 1976, the code has been amended for more than 30 times. In 2002, several considerable changes in this act. So number of adjournment to be restricted. Second point is provision for outside of court settlement to be introduced in 2009. Third one is provision for recording evidence by court commissioner has been made. So fourth point is a provision is made for the filing of an appeal in the court where the decree has been passed. Consolidation and codification. What is a consolidation and what is a codification? So the preamble of the code that it was enacted to considerate and amend the laws related to the procedure to be followed in the civil courts having civil jurisdiction in India. The main reason why some parts of the law are codified is that the law should be assented from the language used in the enactment and not from the proceeding act. The code considerate and amends law related to courts of civil judicial. It also deals with the substantive right but mainly aims to considerate the law relating to civil courts and the procedures. So the case law for this one is Premlal Nahata versus Chendi Prasad Shikaria. So this is the case law for codification and consolidation. Extent and applicability. The code is applicable to whole country except the state of Jammu Kashmir and the state of Nagaland and the tribal areas. Though the amendments of 1976, the provision has also been extended to scheduled areas. Thank you.